The Center for Civil Democracy is a multidisciplinary public policy institute. We are based in Sofia, Bulgaria, but are very active not only in the EU but also North Africa, Middle East, and recently in South America as well. We are the oldest civil society organization in Bulgaria. We have been active for 35 years on a variety of topics that I won't really get into much detail. But our mission is to foster democratic processes and promote good governance through policy research and advocacy. I personally have been with the center for almost 7 years now. I've been working mostly on countering sharp power operations by foreign malign actors, also reforming anti-corruption framework and countering polarization and extremist and violent extremism. Prior to that, before joining the center, I served briefly for 2 years as an assistant prosecutor at Bulgaria's Supreme Prosecutor's Office in the International Department. What the center does most of the time is run policy evaluations of European legislation. We also do assessments of EU agencies according to the better governance regulation. So what I'm going to present to you today is actually a study on assessment on the practical application of Regulation 2018-1805. The research began shortly after the regulation came in power back in 2020. Well, it came in power in December 2020, so we started in the spring of 21. Some of the observations that I'll be mentioning are a bit outdated since the research ended 7 months ago. And as of this month, we already have the new directive, which hopefully will serve to resolve some of the issues that we have flagged in our research. But yet again, all the observations that I'll mention are still relevant to the work of practitioners in order to recognize the environment that you are all working in, to notice the nuances in the supposedly direct effects of the regulation, and what to take in the back of your mind when cooperating with your counterparts in other countries. Confiscation and freezing orders are major means of countering crime, obviously. However, as we've heard already from a couple of the presenters yesterday, EU rates of illicit asset freezing and confiscation remain really low. I believe Alexander yesterday mentioned number 2% for confiscations. We have been cross-matching some data. We believe it stands at about 5. But again, that's really nothing on the overall scope of criminal proceeds in the EU. So our project force endeavored to improve judicial cooperation in the recovery of illicit assets by investigating the practical obstacles to the implementation of the regulation, and also aimed at mitigating some of the disparities in training and creating comprehensive resources for legal professionals, policymakers, but also academics who need to study this subject matter in more detail. Now, the presentation is divided in 3 parts. I'll be briefly speaking about how national governments decide to complement the regulation with additional legislation, both hard and soft law. Then we will discuss some observations from the interviews that we did with legal practitioners across the EU. a total of 79 people, both magistrates, so judges, lawyers, judges and prosecutors, as well as lawyers, on what they believe are the positive aspects of the regulation, what works and what can be done better. So ensuring the effective and efficient implementation of the regulation across the EU is obviously still ongoing. Preliminary analysis reveals that, except for Poland and Portugal, most EU member states have enacted supplementary rules or amendments to facilitate its practical application and bridge existing legislative gaps. This being said, we have to comment on the character of the regulation. We all know it's directly applicable. Yet again, it's one of those pieces of legislation that have been adopted fairly recently, which by its subject matter requires additional secondary legislation on certain aspects. The Parliament and the Commission have gone about this approach quite frequently. Recently, we see quite a few regulations that are supported by additional directives. It's an odd approach, but it appears to be what is needed to tackle the complexity of the subject matter at hand. Some countries, like Luxembourg, have introduced specific legislation to implement the regulation. The Netherlands, Estonia, and France have amended their criminal codes and procedural laws. Elsewhere, gaps were addressed by including challenges on laws on money laundering or mutual assistance in criminal matters. For example, in Cyprus, Belgium, Hungary, Slovenia, Germany, and my country, Bulgaria. Certain jurisdictions, including Italy, Latvia, Austria, Slovakia, Croatia, and Spain, have issued soft law documents or instructions with or without public consultation, unfortunately, to gather feedback on the prospective national legislation. Most of these legislative actions were undertaken either to embody the overarching principle that the regulation envisages, or to foster cooperation between member states next to the regulation. One of the overarching challenges when it comes to the legislation itself relates to the efficient transmission of certificates between competent authorities. And that's why I used my question just to lay the ground. How many of you have actually worked on cases on the legal basis of the regulation? Can I have a show of hands? No one. So you're all applying your national legislation then? Remarkable. Well, yeah, it's not surprising. It was actually very hard to to identify those 79 persons across the entire union who have actually had experience with the regulation. Of course, that was back 2 years ago, so it had only came into force. But again, even today, we see that many practitioners lack awareness and experience in applying this, well, otherwise very important instrument. An outlying challenge to the effective application has been the sharing and compilation of freezing certificates among authorities, among competent authorities. Member states have approached this challenge twofold: by adopting specialized legislation, subject matter, or introducing rules amending criminal procedures. Most provisions enacted by member states address the methods of certificate transmission. Also the languages that are accepted, the appropriate authorities to issue and to receive the orders. Other norms provide instructions for safely exchanging certificates, such as utilizing Europol's Siena platform or Egmont. which the FIUs use. Nearly all jurisdictions that we observed, and we were looking at all 25 countries where the regulation is applicable, are bound by the uh, having to introduce particular soft law instruments that include provisions for document transmission. The A relatively new instrument, Regulation 2023-2844, on the digitalization of judicial cooperation and access to justice in cross-border civil and commercial and criminal matters, will, without doubt, contribute positively to resolving the variety of issues that pertain to the transmission of certificates by introducing a e-codex platform. Now, of course, this regulation has not come into force yet. So we'll see how this is in fact implemented and in practice. Another case of concern when the legislation is considered is the fast and thorough evaluation of urgent freezing and confiscation orders. This has drawn substantial legal attention, particularly the question of how to conduct a fast and thorough evaluation. Some member states like Cyprus, Malta, and Bulgaria have adopted no new regulations beyond those already in force in their countries, while in other member states have introduced modified applicable legislation, specifically providing for facilitating the communication between relevant authorities. Best practices have been observed in Slovakia, Sweden, Slovenia. Time limits are another critical factor that needs to be considered in efficiently handling freezing and confiscation orders. Attaining practical judicial cooperation depends on the duration of the proceedings for recognition and execution of the measures, obviously. Slovakia and Estonia have made explicit in their legal edition that freezing orders must be recognized within 24 hours of receipt. This is really a practice that is rarely seen everywhere else, even in other instruments and national instruments and in civil procedures. This might be considered as really as a go-to recommendation. In Lithuania, the law only specifies when the decisions must be made. The judgment should be rendered within 3 days, but there is no requirement on the actual execution. Certain countries like Croatia, Austria, or Belgium have made it legally binding that orders arising from the regulation must be handled urgently and within a strict time frame. However, this is not explicitly provided for. Other members like Slovakia and Sweden have implemented new provisions to improve their asset freezing and confiscation efficiency in certain specific urgent cases like deteriorating goods. In Slovenia, criminal proceedings linked to the regulations are legally permitted to skip the line and be handled before others, in contrast to the widely accepted custom of handling cases in the order that they have been filed at the courthouse. Denial on grounds for non-execution and non-recognition. Well, the regulation has also set a limited number of grounds for refusing freezing and confiscation order requests. In this respect, several member states did not consider it necessary to specify what is already provided in the regulation. However, it is a complex legal matter to open to interpretation. Other countries have deemed it essential to introduce additional national provisions like the Czech Republic, Austria, Finland, Sweden, etc. National regulations regarding procedural aspects address 3 core areas: timely notification to the issuing authorities, the rights of competent authorities to refuse an order, as well as managing orders based on grounds for non-execution and non-recognition. In instances where national regulations concerning interpretive matters are deemed applicable, states have prioritized the problem of double criminality and, more broadly, the protection of fundamental rights in the case of non-recognition or non-execution of orders. Among all member states, Estonia stands out as having created a thorough domestic legislation meant to address some of the most contentious problems in this aspect. On the other hand, Slovakia and Finland have also introduced specialized norms that specifically address the procedural aspects of handling cases involving non-execution and non-recognition. Several member states have chosen to introduce specific instructions for handling cases involving legal persons. For instance, Latvia is one of the very few countries that passed legislation prohibiting the confiscation of legal persons' property if their registered legal address is in another European country. Poland enables applying relevant criminal confiscation protocols to collective entities for acts prohibited under penalty. Several member states have also established legal frameworks to safeguard the rights of suspects, accused, and third parties' rights affected by freezing and confiscation orders. Most provisions concern the possibility of appealing the order before competent courts, being duly informed of the procedure for recognizing a pending order, or making statements related to one's property interests. In cross-border cases, this opportunity is well, obviously really important and should be considered, since the opportunity of the accused or the owners might be limited, the opportunity to appeal. Research shows that member states have adopted specialized norms to protect victim rights. Those focus chiefly on facilitating the return of seized property to victims, as in the case in the Czech Republic, and Finland and Croatia as well. Some notable measures, however, include requiring prosecutors to justify not returning property to victims as it's legally required in Sweden, for example, or notifying victims of asset freezing and confiscation orders, as is the case in Cyprus. Now, moving to some of the practical challenges that we were able to extrapolate based on our direct contact with practitioners. These are divided mostly in two categories. We had different interviews based on the type of practice that the respondents were involved in. So these are divided between magistrates on the one side and lawyers on the other. Predominant issue highlighted by magistrate resolves around the ambiguity and need for more experience regarding the execution capabilities of judges and public prosecutors as cases under the regulation goes. This ambiguity is partially attributed to the absence of common standards delineating the powers and responsibility attributed to relevant authorities in different member states. The variation in procedural requirements, where some jurisdictions necessitate a public prosecutor's application to initiate confiscation measures, while others empower judges to enforce these orders ex officio. This only exemplifies the inconsistency in the application of the regulation in its direct effect of its norms. The lack of uniformity complicates the procedural landscape and amplifies the oversight role of public prosecutors, traditionally limited to managing execution measures. In addition, the widespread inexperience with the regulation underscores the pressing need for specialized training and the establishment of dedicated units within public prosecutors' offices to handle confiscation and freezing orders more effectively. The timing of for executing orders, particularly urgent freezing orders, as I mentioned, presents another contentious area for magistrates across the EU. They reflect a divergence in opinions regarding the feasibility of adhering to specific timelines, expressing difficulties in meeting the stipulated deadlines. This viewpoint discrepancy is further complicated by general inexperience with urgent freezing orders, especially junior members of the bench. Um, in This is further complicated by the need to, well, this stipulates the need to moral consensus on the necessity and practicality of imposing definitive time limits for implementing measures emanating from the regulation points, to a broader issue of preparedness and capacity among the judiciary. Complications arising from the execution of freezing and confiscation orders and the transfer of property for confiscation predominantly stems from the communication and coordination deficits among relevant authorities across member states. The challenge of identifying the responsible authorities has been a relevant one, and also eliciting timely response is compounded by varying legal frameworks and magistrates' limited training and practical experience concerning the regulation. These procedural discrepancies often leave authorities grappling with non-domestic measures mandated by the issuing state, necessitating ad hoc solutions such as executing equivalent domestic actions, consulting Eurojust, for example, or the EGN. Directly engaging with issuing authorities is also has been reported, even though unofficial contact is widely not recognized as a good practice. To address all these challenges, member states have adopted various measures to bridge the existing gaps. These would include enhancing practitioners' trainings, developing detailed guidelines, and also improving interstate communication systems like the Schengen Information System. Challenges related to the standard certificates used to enforce orders have also been identified as a point of contentions by magistrates. While most magistrates find that certificate is comprehensive and valuable, concerns have been raised specifically about their consistency, lack of clarity, and the burden that they impose. Challenges such as improper filling, inefficient information, translation issues are really notable. Further exacerbate the difficulties in effectively completing and processing these certificates. I'll go into more detail about the translations a few slides down. Regarding using legal remedies to challenge orders, magistrates in various member states have reported instances where suspects availed themselves of such measures. However, none reported refusing an order on fundamental rights of double criminality, suggesting a nuanced interplay between legal oversight and operationalization of the regulation. The majority of magistrates across the EU recognize the conception and adoption of hard and soft law provisions as facilitating factors. So it is the overall opinion that the regulation cannot be applied in directly. These additional guidelines, soft law, have been instrumental in clarifying the regulation's application, resolving practical challenges, but sometimes creating more. Conversely, a minority of magistrates perceive that provisions as overly concise and advocating for a more direct application of the regulation itself. A few challenges have been reported or outlined. We have summarized, as I said, many conversations by lawyers. A central concern for them pertains to the availability of legal remedies, naturally, for challenging certificates in the context of recognition and execution procedures under the regulation. While lawyers acknowledge the existence of legal avenues to contest freezing and confiscation orders, a notable gap is reported and identified in the suspensive effect of such challenges. In essence, the appeal proceedings, although provisions, continue the implementation of measures in questions, thereby placing a significant limitation on the efficacy of such legal challenges. This scenario is further complicated by the rare instances of legal practitioners contesting certificates, especially in executing states or on the grounds of double criminality, highlighting a potential area for legal uncertainty and underutilization of the available remedies. The issue of time limits I already mentioned within certificates, particularly concerning the duration of measures taken due to an order, presents another area of divergence among lawyers in specific. The debate mirrors that of the magistrates, with opinions split between the necessity of a specified timeline for lifting measures and the potential determined such limitations could pose to the regulation's objectives. The consensus leans towards allowing the issuing authorities court to quash or renew orders within a reasonable time frame, suggesting a preference for flexibility and judicial discretion in managing the persistence of orders. Lawyers also identify significant obstacles in executing freezing and confiscation orders, predominantly from communication challenges and the need for harmonization across member states. The diversity of legal and administrative approaches complicates the effective enforcement, underscoring the need for enhanced coordination and unified approach to address these disparities effectively. The awareness of hard and soft law provisions relating to the regulations implementation within the national frameworks is fairly widespread between legal practitioners. The awareness of the national legislation, obviously. These provisions are recognized as positive factors for facilitating the application of the regulation. However, the determination of national competent authorities in the procedural aspects of relevant proceedings stipulates significant areas for future improvement. These areas concern more precise guidelines and more defined processes to streamline the application of the regulations norms across different jurisdictions. Another set of challenges relates to certificates used in enforcing the regulation, particularly concerning their completeness and clarity. This has been raised by different judges, by different lawyers in different jurisdictions. The potential for incompleteness or lack of clarity in information provided by issuing authorities raises concerns about the effectiveness and the efficiency of the certification process altogether. All of these challenges have helped us extrapolate a set of recommendations that we have posed to the Commission and to national governments. We presented this work a couple of months ago in Brussels to a number of policymakers from the Parliament and the Commission, as well as representatives of Eurojust presently present. Central to the regulations jurisdiction, as outlined in its Article 1, is the explicit exclusion of freezing and confiscation orders issued on civil and administrative grounds, directing the focus squarely on criminal proceedings. The adjudication of what precisely constitutes proceedings in criminal matters is not left, obviously, to arbitrary determination, but is instead guided by the Engel criteria, um, the litmus that is used and developed by the courts of the European Union, that assesses the domestic classification of the nature of the offense and the severity of the penalty to ascertain the criminal nature of a measure. This application of the Engel criteria ensures a harmonized approach across the Union despite the inherent complexities and nuanced distinctions present within the concept of criminal matters. Expanding the scope of criminal matters to encompass a variety of FCOs, irrespective of the directive encapsulated within the old directive, and including those pertinent to criminal investigations, the regulation ventures beyond traditional boundaries and is really a landmark legislation that we hadn't seen before it. This expansion indicates the EU's commitment to adopting a comprehensive stance on judicial cooperation, but as I already mentioned a couple of times, it also stipulates the need for further secondary legislation on the subject matter. Salient feature of the regulation is its emphasis on upholding defendants' fair trial rights. This is particularly evident in the contemplation of non-conviction based confiscation systems, where the regulation navigates the balance between endorsing the recognition of NCBCs and safeguarding the fundamental rights to property and fair trial. The alignment of the non-conviction based systems with the principles of legality, legitimate purpose, and proportionality, as enshrined in the convention, underscores the EU's dedication to ensuring that measures do not contravene established human rights standards and other rights. Even in instances where the legal framework and the executing states lack a corresponding mechanism, the regulation's approach to the recognition of freezing confiscation orders is illustrative of the principle of mutual recognition and trust that underpins EU judicial cooperation efforts. The efficient and effective implementation of the regulation is pivotal for the EU's broader objectives in combating cross-border crime, necessitating a series of recommendations tailored to enhance the efficacy of mutual recognition of freezing and confiscation orders. While diverse in their specifics, these recommendations aim to fortify the legal and operational frameworks underpinning EU's efforts in this domain. A fundamental aspect, a fundamental aspect resolves around the need for clarified and enhanced communication among authorities within member states. Given the intricacies of determining the scope of criminal matters, a task nuanced by applying the Engel criteria as already described, authorities must engage in proactive communication when uncertainties arise. We have heard of several cases where competent courts went on to deny recognition of orders in cases where the uncertainties could have been easily resolved by a single email or a call, given they had enough information to on how to contact the issuing authority. The interplay between the regulation and the formal directive, the old directive 2014-42, concerning the European investigation order, highlights an avenue for reinforcing the mutual recognition of freezing and confiscation orders. By leveraging the complementarity nature of these instruments, authorities can significantly enhance the collection and preservation of evidence across border. This has been the case in a couple of high-profile cases where issuing authorities decided to um, issue synergetic orders in an effort to ensure that the assets are effectively removed from suspects holding. The designation and validation of competent authorities within member states emerges a critical component in the framework. The appointment of central authorities to assist with the administrative tasks related to the recognition of FCOs, coupled with the facilitative roles of the European Judicial Network and Eurojust, underscores the importance of a structured approach to authority designation. This structured approach would ensure that the issuing and executing of FCOs are carried out by entities recognized for their competence, thereby enhancing the regulation's operational integrity. The comprehensive completion of freezing and confiscation certificates is probably the most vital step towards ensuring the effective execution of freezing and confiscation orders. As it has been mentioned already, the certificates, though being quite straightforward in the character, sometimes confuse practitioners who are not sufficiently aware of them, which is sometimes based as ground for non-recognition or non-execution. The level of precision and comprehension and completion of FCs is essential for the smooth processing of requests. The principles of necessity and proportionality are paramount considerations in issuing freezing confiscation orders. The authorities must conduct cost-benefit analysis to prevent undue burdens, especially concerning minor offenses and properties of nominal value. We have also discussed this before, well, yesterday, I believe. Taking such an approach would not only contribute to streamlining the execution process, but also align the enforcement actions with fundamental rights considerations, ensuring the mutual recognition and execution of FCOs are carried out in a manner that respects the principles of justice and equality. Addressing linguistic challenges constitutes another pivotal area of focus. As I already mentioned, we have been noting instances where language was the only reason, the language barrier was the only reason for non-execution of orders. While promoting inclusivity, the regulation's flexibility regarding language use poses practical hurdles in cross-border cooperation. One of the recommendations that me and my colleagues came up with was for simply adopting English as a working language, even or a descriptive language that could ensure the effective recognition of FCCs. Now, everything that we have looked at during those two years has been collected in a training digital ecosystem that includes three main components. On the one side, knowledge sharing repository, which is actually an interactive map. When you access the knowledge repository, you are faced with a detailed information. It's pretty much a database with information on freezing and confiscation rules across and practices across all EU member states bound by the regulation. For each member state, the web interface presents a list of a description, an overall description of the state of play, a list of relevant legislation and soft law, also a list of contact points and authorities responsible for issuing and execution of orders. Another component of this digital ecosystem is the virtual learning environment. This is pretty much MOOC training focused on the regulation and its implementation, and has been developed with help of expert panel of practitioners from all practices in an effort to increase capacity, raise awareness, and it features an online open course. It is freely accessible. You can register it, and it takes 64 hours to complete, and of course get your certificate on the training. And last but not least, a really important component of this digital ecosystem is the force community. This is pretty much a forum, something that every one of you is used to, I guess. A forum of practitioners across the entire EU, with whom everyone can share data, can ask for advice or help in an informal channel, just to make their life and work easier. Now, I'll end with this a few words on the way forward, as this is actually the title of my presentation today. The regulations implementation has obviously encountered uneven application and a notable lack of uniformity across the union. And this variability underscores the necessity for concentrated effort to not only familiarize practitioners with the regulation, but also harmonize its application. We believe that the newly adopted directive can go even further in establishing the a high standard within those minimum standards that it already has. Of course, we will see how these two instruments complement each other. But developing a set of guidelines to standardize the application of the regulation across all member states would require creating uniform procedures for the issues for the issuance, recognition, and execution of freezing orders. And this approach should be complemented by implementing comprehensive training programs within the EU as a whole, but also in international legal schools. Programs should include case studies, best practices, but also interactive workshops where people can simply discuss the matters that they're facing in their daily job. Establishing a centralized EU database for freezing and confiscation orders would also improve transparency and expedite processing. We'll see how the new e-codex under the digital regulation will work with. But we believe that this database could really enhance existing information sharing and cooperation mechanisms that are currently used as Siena and Egmont. Member states should be encouraged to amend and, if necessary, review on a occasional basis their legislation that relates to the regulation. Irregular evaluations of the implementation and impact of the regulation should also be put in place. Of course, there will be an impact assessment done by the Commission next year, I believe. But these should be complemented by national regulations as well, and should be put forward in recommendations to the Commission. Beyond the EU, engaging with third countries and international organizations to extend the principles of mutual recognition and judicial cooperation in us recovery is really vital to addressing the global nature of financial crime and implementing a more comprehensive approach to ensuring that crime does not really pay anymore. With this, I'll end the presentation. You can look up our website to see more what we do more on the topic on judicial cooperation, and of course I'm available to answer any questions, to do research and any other topics that you might have now.